If you're studying for the California real estate exam, you're in the right place. I passed on my first try using these exact tools. I'll walk you through exactly what you need to know, no fluff. Hit subscribe so you don't miss the next video, and we'll study together. Let's get into it. Property ownership and land use controls and regulations. Expect 15% of the exam to be on this topic. Classes of property. Land. The Earth's surface extending downward to the center of the Earth and upward to infinity, including permanently attached natural objects. Real estate. Land plus all the things permanently attached to it, naturally or artificially. Real property. Real estate plus the interests, benefits, and rights included with real estate ownership. It's helpful to remember that land is less than real estate, which is less than real property. Real property is the land, the real estate, all of it. And that kind of goes with the alphabet. So L comes before RE, which comes before RP. That's how I remember it. Improvements. Artificial attachments to land that include things like fences, buildings, and walkways. Personal property. Everything owned that isn't real property. 5 basic tests can help determine if an item is real or personal property. MARIA. MARIA stands for the method of annexation, which refers to whether or not an item is attached to property and how permanent that attachment is. Adaptability for use refers to how an item is adapted to real property. If removing an item would change or eliminate the use of the property, it's likely real property. Relationship of the parties. In general, the courts tend to favor a tenant's take on an item over the landlord's, and a buyer's over the seller's. Intention in placing. If an item was intended to be temporary, then it's less likely to be considered real property. Agreement of the parties. The simplest and first test is whether the parties have agreed an item will stay or go. Quick pause. If this is helpful, tap subscribe so you can find this later when you're cramming. Okay, back to it. Fixture. Anything permanently attached to the land or to permanent structures on the land. Fixtures are part of real property and are conveyed with the sale of the property unless the parties negotiate differently. Fixtures that are removed from the improvement before an agreement of sale becomes personal property again through the process of severance. Annexation. This is the process of converting personal property to real property. Trade fixture. Anything that's attached to leased land or structures and is used in conducting business. So a pizza oven for a restaurant that serves pizza. Rights and responsibilities differ depending on the commercial lease agreement, but usually tenants may remove trade fixtures when the lease terminates, though they must repair any damage created by removing the fixtures. Trade fixture, pizza oven. Real property is commonly categorized according to its use. Residential, single-family or multifamily dwellings, commercial, income-producing properties, retail stores, restaurants, offices, hotels, industrial, warehouses, factories, agricultural, farms, ranches, timberland, etc. Special purpose, hospitals, churches, schools. Property characteristics. Physical characteristics of land. Immobility. The geographic location of land is fixed and can't be changed. That's why it's always location, 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 because you cannot change that. Indestructibility. Improvements may deteriorate over time, but the land itself will not. Uniqueness, non-homogeneity. One piece of land is never exactly like another. Economic characteristics of land. Scarcity. You can't make more of it. The land we have now is the land we'll always have. Improvements. A land's value can be positively or negatively affected by the improvements placed on it. Permanence of investment. Some improvements are long-term, stable investments with stable returns over time. Situs, location, area preference. A property's value depends in large part on its location. The spots next to the beach, for example, are almost always going to be a little more valuable than the houses across the street, not right next to the beach. Encumbrances. Encumbrance may be financial or physical. It limits the owner's use of property and can affect marketability and value. For example, liens are a form of financial encumbrance, while easements and encroachments are physical encumbrances. The property's deed and title history should list known easements. Subdivision maps maintained by county recorders' offices may show known easements that exist on lots and parcels. An on-site land survey can help determine easements, encroachments, and lot size. Liens. A lien is a creditor's legal claim to the property of a debtor. It prevents the debtor from transferring the property until the debt has been repaid. It may allow the creditor to sell the property through a court sale, foreclosure, and be repaid from the proceeds of the sale. A lis pendens is notification to the public that a legal action, such as a lien, is pending and could impact title to a property. A lien can trigger a foreclosure if the property transfers to a new owner and the lien remains unpaid. Lis pendens, pending. General liens affect real and personal property and include judgment liens, federal and state tax liens, and decedents' debts. Specific liens affect the specific real property to which they're attached by agreement of law. These include mortgage liens, real property tax liens, mechanics liens, special assessment liens, vendor and vendee liens, and HOA liens. A general lien affects everything in general, is how I like to remember it. It affects real and personal. It affects the whole dang deal. Everything. Specific only affects specific. Another way to classify liens is as involuntary or voluntary. An involuntary lien is one created without the property owner's consent, like a property tax lien. A mortgage lien, because the property owner chose to enter into a mortgage, is voluntary. A mechanics lien is one a vendor of goods or services places on the property. A statutory lien is created by law. It's an involuntary lien created without any action required by the property owner. An example would be property taxes, of course. An equitable lien is created by a court of common law. It does not give right of possession, but it does encumber the property. Real quick, here's how I remember the liens. A mechanics lien. If you didn't pay the mechanic for the work he did on your car, he can place a lien on you and your property. A statutory lien is created by law. It has to do with state laws, statutory state law, taxes. Equitable lien, court of common law. California has a homestead exemption, which prohibits a creditor from forcing the sale of the owner-occupied home to repay a debt. It also allows a homeowner to protect a certain amount of equity from creditors if the home is transferred. In general, the date the lien is recorded determines the order of priority when paying debts from the sale of a foreclosed property. The lien that is first to record is paid first because it was recorded first. However, certain types of liens, such as property tax liens, take priority over other liens regardless of the date of recording. In other words, certain liens get to skip the line. In California, tax liens and special assessments take priority over other liens. Assuming the mortgage deed of trust is the senior lien and is next in line, that's paid next. Then the homestead exemption is taken out. After that, the levying authority is reimbursed, and then all others are paid in order of recording. Easements and licenses. An easement is a non-possessory right acquired by one party to use another party's land for a special use. These are often acquired through written agreement. The dominant estate. The property or individual who uses the easement holds the dominant estate. It's said that the dominant estate enjoys the easement. The property on which the easement lies is the servient estate. It's said that the servient estate suffers the easement. It's serving the other estate. The property deed and title history should list known easements. Plat maps may also show easements. Categories of easements include easement appurtenant, attached to a specific parcel of land, which transfers or runs with the land, and gives the dominant tenement rights to use adjoining property or the servient tenement. Easement in gross, granted to a specific individual or entity rather than attached to the property itself. Easement by necessity. This easement type can only be created for the purpose of ingress and egress. Easement by prescription. This easement isn't legal and is created through continued, uninterrupted, obvious, exclusive, and adverse use of someone's property without permission. An easement can be created by express grant or express reservation in a grant deed. The grantor determines the dominant and servient interest. Implication of law. The circumstances and conduct of the parties creates the easement. Since any parcel of land must be allowed access, this is usually how an easement by necessity is created. Condemnation. This is when the government exercises its right of eminent domain to take a portion of private property to create roads or sidewalks by contract. This is an agreement reached between the parties that isn't part of the deed itself. An easement may be terminated by express agreement, merger of the dominant and servient tenements, abandonment, destruction, lawsuit, adverse possession, excessive use, allowing legal termination, estoppel. A license is temporary permission for one person at the discretion of the property owner to do something on another's land without actually possessing any interest or ownership in the land. A license is not assignable or inheritable. Encroachments. Encroachments are structures or objects built on another's land without permission. Encroachments are always, by definition, illegal. A survey establishes the boundary lines of a property and may help identify both encroachments and easements. Types of ownership: freehold and leasehold estates. A freehold estate is an interest in real property where the owner's possession of the property isn't of a fixed duration, as it would be in a leasehold estate. Fee simple estate, aka fee simple absolute, is a type of freehold estate that conveys the most rights available. Property held as a fee simple can be sold and is inheritable. Fee simple estates may be limited by both public and private restrictions, such as zoning ordinances or restrictive covenants. The owner holds rights to the property on the surface of the land, above the land, and below the land, unless those rights have been separated from the property and conveyed to a different owner. Fee simple estates must pass through the probate process before legal distribution to heirs. Survivorship and inherited rights vary according to state and local laws and by how the title is held. Fee simple defeasible is a type of freehold estate in which ownership is subject to either occurrence or non-occurrence of a particular event. The two categories of fee simple defeasible estates are fee simple determinable and fee simple subject to condition subsequent. With a fee simple determinable estate, the current property owner conveys ownership to a new owner as long as some event does or doesn't occur. For example, Tommy Tom gives a plot of land to a local parks district as long as the district only uses it for a community garden. Go Tommy Tom. He gives the possibility of reverter to his son, Jojo Joe, someone named by Jojo Joe, or Jojo Joe's heirs. If the parks district changes the property's use, the estate automatically ends, and the property reverts to whoever holds possibility of reverter. In this case, Jojo Joe, someone named by Jojo Joe, or Jojo Joe's heirs. With a fee simple subject to conditions subsequent estate, the current property owner conveys ownership to a new owner on a specific condition. For example, Marta conveys her home to her son, Rickon, on the condition that the property remain residential. If Rickon converts the property to some other use, like a bowling alley, the estate doesn't automatically revert to the original owner, but Marta, or Marta's other heirs, successors, have the right to reacquire full ownership, but they'll have to go to court to do so. What can I say? Marta does not support bowling. So, a life estate is a type of freehold estate in which ownership is limited to someone's lifetime. The future owner is determined based on the life estate's terms. An ordinary life estate is based on the life of the estate holder life tenant. For example, Kristanicia gives her son TT a property for his life. TT gets to use and live on the property as long as he's alive. When he passes away, the property automatically goes back to ding ding ding, Kristanicia, or whoever holds the remainder interest. Pure autre vie is an estate based on the life of someone other than the life tenant holder of the life estate. If Kristanicia gives TT a property for the life of Philip, TT gets to use and live on the property only while Philip is alive. When Philip dies, the property will go back to Kristanicia, or whoever holds the remainder interest. During the term of a life estate, the estate holder must keep the property in good repair. Any act by the estate holder that significantly reduces the value of the property at the end of the life estate is called an act of waste. The estate holder or another party with interest in the property, for example, heirs to the estate holder, may file a lawsuit to stop the waste and/or seek damages. When a life estate ends, ownership of and interest in the property is determined in one of two ways. Remainder, ownership will pass to a remainderman instead of the party who established the life estate. Reversion, ownership will revert to the life estate originator or the originator's successors or heirs. When a life estate ends, the remainderman or reversion holder holds the estate in fee simple. A leasehold estate is an estate in which the holder has a possessory interest in a property but no ownership. Types of leasehold estates include: an estate for years is a lease that ends on a specific date and must be renewed by mutual agreement between the landlord and tenant, aka chattel royale. In California, an estate for years is known as a periodic estate, so it's an estate from period to period. A periodic estate is a lease that automatically renews at the end of its term, such as a month-to-month lease. An estate at will is a lease without an established ending that can be terminated by either party. An estate at sufferance is one in which a tenant, referred to as a holdover tenant, didn't leave when the lease expired. In California, a long-term lease is 6 months or more. A short-term lease is less than 6 months. Bundle of rights refers to the rights extended to a property owner to use the physical components of land, such as the surface, subsurface, and air rights. The bundle of rights includes possession, the right to occupy the property and recognition as holder of the title; control, the right to use the property, build on it, or grant an interest in the property to others, provided that interest is within the law and any community regulations; exclusion, the right to decide who may or may not access the property; enjoyment, the right to use the property legally without harassment or interference; disposition, the right to sell or convey the property. When purchasing property, the buyer may or may not receive all the property rights in the bundle of rights. For example, the property may be leased to someone else, thus denying the owner all of the rights. The mineral, air, or water rights may have been split off or sold separately. Mineral rights, also known as subsurface rights, are the rights to drill or dig for minerals on the property. Air rights refer to the right to use the area in the sky above a property. Okay, believe it or not, we've actually covered title, so go check out those videos if you want to review, but here's just a super quick brush up and why title even matters while we're going over land use. So here's how that ties in. Ready? Let's go. Joint tenancy includes the right of survivorship, which means that the surviving co-owners own the property of a joint tenant who dies. If there are only 2 joint tenants, the death of one dissolves the joint tenancy. The remaining tenant becomes the owner of an estate in severalty. If there are more than 2 joint tenants, a deceased tenant's ownership transfers in equal parts to the remaining joint owners. When a joint tenant sells interest in a property, the buyer doesn't become a joint tenant with the other owners. The buyer is a tenant in common with the remaining joint owners. That's because the unities of time and possession don't apply. This is super important, this concept. There will absolutely be a question on your exam about this. Tenancy by the entirety. California doesn't recognize tenancy by the entirety, but some states do use this form of ownership. It requires the 4 unities of joint tenancy, plus a 5th unity called unity of person. This refers to married couples as one legal entity, so this form of ownership may only be used by married couples. Some states extend this right to domestic partnerships and civil unions. Co-owners have the right of survivorship. If one dies, the other becomes the sole owner of the property. Since tenancy by the entirety is inherently based on the owners being married, in the event of divorce, both parties automatically become tenants in common. If the ex-spouses don't want to co-own the property, each is free to sell their individual interests. Tenancies by the entirety are not allowed to convey a fractional interest in the property. Transferring the property requires both parties' consent. Community property. California is a community property state. In general, property purchased during a couple's marriage or domestic partnership becomes community property. Each spouse or partner has an equal ownership share in the property. Property owned by either spouse, partner, prior to the marriage is considered separate property unless it's converted to community property by an agreement between the spouses. Property acquired during the marriage partnership by one individual by inheritance or gift remains separate property. Income generated by separate property remains separate property. Income generated by wages earned during the marriage or from community property is community property. The spouses, domestic partners may agree in writing to hold property as separate property rather than community property. When real estate is purchased in California by a married couple or domestic partners, the deed may specify that the title is held as community property or as community property with the right of survivorship. If the right of survivorship isn't specified, a spouse or partner's half interest in the community property can be willed away from the surviving spouse or partner. When the right to survivorship is specified, the property automatically becomes owned in severalty by the surviving spouse. Both co-owners must consent to a transfer of the property. A lien may be placed on the community property due to unpaid debt of an individual co-owner. California subdivision law defines 3 types of subdivisions. Standard subdivision, where land is subdivided into parcels with no shared ownership between the owners of the subdivided parcels. Common interest subdivisions, where parcel ownership is separate and all owners have a shared interest in common areas, regulated by common interest open meetings laws, and undivided interest subdivision. Land is not subdivided into parcels. 5 or more co-owners take title as tenants in common. Examples of this are campgrounds or RV parks. The types of common interest subdivisions defined by California's subdivision land law are a planned development. Parcels of land are independently owned, and owners share interest in common areas, usually through an HOA. Community apartment project. Owners are tenants in common with an undivided interest in the land and a right of exclusive occupancy for their respective units. Condominium. Owners have an undivided interest in the common areas and a separate interest in a specific unit as defined by boundaries described on a recorded plan. Stock cooperative. A corporation owns the entire property. Each shareholder receives a right to exclusive occupancy of a unit and owns shares in the corporation, but doesn't hold title to the real property. Limited equity housing cooperative, a type of stock cooperative usually used to develop affordable housing. It can include certain restrictions, such as requiring owner occupancy and imposing limits on resale values. Timeshares. A timeshare is a form of property interest, usually used for vacation property. Each co-owner has the right to use a specific portion of the property for a period of time. It can be held in 2 forms. A timeshare estate is fee simple ownership. Timeshare estates may be sold or inherited. A timeshare use is a right to use interest. Right to use timeshares can't be inherited since no actual ownership of the property is involved. The owner of a timeshare use has the right to use the property under the specific terms of a timesharing agreement. In California, timeshare sales are regulated by the Vacation Ownership and Timeshare Act of 2004. Descriptions of property. Legal descriptions. A legal description is the most accurate way to identify the exact location and boundaries of a specific parcel of property. A property's legal description is created with a survey and may be found at the county recorder's office, registry of deeds, or through a title company. 3 primary types of legal descriptions are meets and bounds, rectangular government survey system, RGSS, also called the Public Land Survey System, PLSS, and the lot and block, also known as recorded plat. Meets are the direction and distance of a line forming the property's boundary. Bounds are physical features that define the boundaries of a property. Meets and bounds descriptions are characterized by a point of beginning. This is where the description both begins and ends. It also uses monuments to mark boundaries. The monuments are thought to have more credibility than the measurements. Monument. A permanent physical marker used in a meets and bound description that can be man-made or natural. It could be a tree, a creek, a rock, a stake placed in the ground. Monuments are used within a meets and bounds description to mark points at which there is a change in direction as one follows the boundary of the parcel. A monument is also the point of beginning of a legal description in the monument system, which is infrequently used. The RGSS, regulated by the U.S. Department of the Interior's Bureau of Land Management, divides land into townships and further into sections and fractions of sections. The principal meridian is the north-south line that runs through an initial point in the RGSS. The baseline is the east-west line from which measurements originate. East-west lines of a survey are called township lines. North-south lines are called range lines. There are 37 principal meridians in the United States. Each parcel is described by referencing the principal meridian and baseline that is appropriate to the township where the parcel is located. Every township is 6 miles square, or 36 square miles. Every section is 1 square mile, which is also 1 mile squared. Go figure. Lot and block. Lot and block systems begin with a reference to either meets and bounds or RGSS, then divide the land into lots with numerical descriptions of each parcel. A plat map with the lot descriptions is recorded in the land records. Lot and block divisions include streets, access roads, and other important features. Land measurement. Personally, here are the land measurements I found most helpful to memorize. 43,560 square feet is 1 acre. 5,280 linear feet is 1 mile. 1 hectare equals approximately 2.47 acres. 640 acres is 1 square mile. 1 square yard equals 9 square feet. Square feet divided by 9 equals square yards. Square yards times 9 equals square feet. Front foot, or frontage, is the length of property along a street, highway, or waterway. Air lot diameters are measured based on the perimeter of the land parcel directly beneath. Air lot heights are established by the city or other governing authority that has jurisdiction. Datums and benchmarks are used to measure elevation. Datum is a horizontal point of reference from which surveyors measure depth and height of various land elevations. A benchmark is a point where the exact elevation is known and marked with a brass or aluminum plate. Surveyors can use this as a starting point to measure other elevations. Measuring structures. Structure area is stated in square units, for example, square feet, square yards, etc. National standards for measuring structures are: finished areas are the only spaces that can be included. Garages are never included as finished square footage. Finished spaces are only included if they are attached to the main property via finished stairways or hallways. Finished spaces are only measured if the ceiling height is at least 7 feet. There are exceptions, for example, if the space is under a stairway, sloping ceiling, or a beam that reduces ceiling height. Super quick review: area of a triangle is half of the base length times the height. If you need to, break irregular shapes into basic shapes. Try and make it a square, a rectangle, a triangle, and calculate the area of each, then add for the total area. Government rights in land. Property taxes and special assessments. Taxation is a governmental police power that permits it to meet the need for public works by creating funding through a stable source of income that shares the burden among many citizens. Ad valorem taxes, based on the property's assessed value. Special assessment taxes, imposed only on properties within a defined special assessment district. These taxes are used to fund local improvements or services, such as sewers or streets. Benefit assessment is similar to a special assessment, but doesn't require a special assessment district to be established. Instead, all property within an improvement area that will benefit from the improvement is included in the assessment. Typical purposes include streetlights, transit, and emergency services. Delinquent property taxes create a lien on the property that is satisfied when the tax is paid. In California, January 1st is the tax lien date, when the lien attaches to the property for which the taxes are unpaid for the previous fiscal year. The fiscal year in California is July 1st through June 30th. Property tax liens take priority over all other property liens. Taxpayers can release a tax lien by paying back all taxes owed along with assessed penalties and a redemption fee. When a property owner redeems the property, the taxing authority issues a certificate of redemption. In California, the property owner has 5 years to settle the delinquent tax debt. If all back taxes, fees, and fines aren't paid by that time, the taxing authority has the power to sell the property at public auction. California property tax legislation. California makes the following properties exempt from property taxes: government-owned, owned by a charitable organization, hospitals, churches, nonprofit entities, and some veterans and disabled veterans may qualify for property tax exemption as well. A homeowner's exemption allows a reduction of $7,000 in assessed value for owner-occupied houses. Homeowners must file an exemption claim form with the county assessor. Proposition 13 passed in 1978, limits the amount of property tax a property owner may pay and the amount of any yearly increase. The law established a base value for property as of February 28, 1975, and capped ad valorem property tax rates at 1% of that value. For assessment purposes, a property's value can't increase by more than 2% per year, an inflation factor. The property's base value can't be reassessed at a higher amount unless its ownership changes or another reassessment event occurs, such as a property improvement. When a property changes ownership, the base value is reset at the property's full market value as of the date ownership changed. New construction's base value is set at its full market value as of the date construction is completed. The Mello-Roos Community Facilities Act of 1982 allows a defined community to fund community improvements through a special tax. The voters in the defined community must approve the special tax by a 2/3 majority. Typically, a developer creates a community's facilities district and funds development of infrastructure by issuing a bond that must be repaid by the property owners in the district. The assessment becomes a lien on those properties to ensure repayment. The assessment appears on the property tax bill as a separate line item. Seller disclosure of a property's location in a Mello-Roos district is required. The Morgan Property Taxpayers' Bill of Rights went into effect on January 1, 1994, providing taxpayers with the means for reviewing, appealing, and correcting property tax bills and assessments. Additional statuses used to authorize taxes for community improvements are Vrooman Street Act, Street Improvement Act of 1911, and the Improvement Bond Act of 1915. Eminent domain, condemnation, and escheat. Eminent domain. The power of a government to appropriate private land for public use. The Fifth Amendment to the Constitution requires the government to fairly compensate private owners for property taken through eminent domain. Taking. Governmental appropriation of property. A taking may or may not use the power of eminent domain. Condemnation action. The process of taking title and physical possession of private property using the government's power of eminent domain. The property owner is paid just compensation for the value of the property. Inverse condemnation. The government takes private property but fails to compensate the owner. Property owners are forced to file suit to obtain compensation. The taking may be physical, through occupation, or regulatory, where government regulations deprive the owner of the property's beneficial use and cause the property to lose its economic value. Escheat. The state's power to take the property of a decedent who dies without a will, heirs, or creditors. Public controls. Police power is the government's authority at any level to do what it can to ensure the health, safety, and welfare of its citizens. Police power includes licensing, public services, zoning, and building codes. Zoning and general plans. Zoning is a police power exercised by a state, city, or town government that classifies land based on its current or intended usage. In California, zoning must comply with a jurisdiction's general plan, which is a comprehensive policy for land use and development. Zoning ordinances. Local laws or regulations that implement the general plan by regulating zoning and land use. Regulate things like lot size, building height, and permitted uses within each zoning classification on a zoning map. Zoning ordinances may not violate the Federal Fair Housing Act.
That is actually a zoning issue.
The planning board ensures that community growth is controlled and orderly. The board develops the general plan, which includes a budget. Other terms used for the general plan are master plan and comprehensive plan. California state law requires every city and county to have a general plan. Once a general plan is developed, it must go through an adoption process, and then specific plans can be developed. General plans in California must include these 7 elements. Standards for land use and density, circulation patterns for public utilities and transportation, housing for a variety of income levels, conservation to protect natural resources, open space, noise control, and public safety. Additional planning elements may also be required, such as coastal protection, historic preservation, and management of hazardous waste. Zoning compliance is often monitored by requiring developers to make application for permits, which are only granted if they're in compliance with zoning ordinances. Common zoning classifications are residential, commercial, combination, mixed use, industrial, agricultural, open space, parkland, and recreation area. Incentive zoning allows otherwise prohibited development in return for the developer providing a community benefit. Bulk zoning regulates the density of a given area by requiring certain building height limitations, lot width, setback requirements, etc. This applies to both residential and commercial zoning. Aesthetic zoning is a way to ensure the visual and architectural consistency of an area. Oftentimes you'll see chains that look different in different areas. For example, a mountain town compared to a coastal location. That chain suddenly has a very different look, and that's thanks to aesthetic zoning. Downzoning is the process of assigning a lower density use zone to an area previously allowing a higher density. Density zoning refers to a number of units per measurement, such as houses per acre. Spot zoning rezones a specific property for use within another zoning area. Exclusive use zoning allows only one type of land use in a particular zone or district. Mixed-use zoning combines complementary uses, such as residential and commercial, on one type of land. Cumulative zoning allows any use that would be allowed in a higher use, less intensive zone to also be permitted in a lower use, more intensive zone. Cluster zoning allows a developer to place residential properties close together, leaving large open spaces for community amenities. Zoning actions may include non-conforming use, deviates from current zoning but is grandfathered in, moratorium, temporarily halts new property development, special use permit, aka conditional use permit, allows use that's not normally permitted but is considered an allowable use within that zoning, such as a church within a residentially zoned area. Variance is a permitted deviation in the zoning ordinance requirements, typically granted when the zoning has created a hardship or burden on the property owner. Both special use permits and variances require a public hearing before they're granted. Many localities have a zoning appeals board, which oversees challenges to zoning actions. Subdivision, land that's divided into lots for development. Plat map of a subdivision that represents a tract of land, showing the boundaries and location of individual properties, streets, easements, and other pertinent information. A developer submits the plat map to a planning board or zoning commission. California's Subdivision Map Act requires coordination of subdivision design, streets, and utilities with the municipality's general plan. At the federal level, the Sunshine Act is part of the Freedom of Information Act. Each state usually has its own version of the Freedom of Information Act or a Sunshine Law. In California, the Public Records Act and the Brown Act protect the public's access to information. Local governments may also have their own sunshine laws. Meetings held by planning and zoning boards must be open to the public because of sunshine laws. Building codes. Building codes are rules that specify the standards to which certain building projects must comply. These codes help ensure safe, properly functioning buildings for their occupants. Building codes address the method of construction, materials used, and the building's safety and sanitary standards. California uses uniform building codes published by the International Code Council, ICC. Local jurisdictions may impose additional standards specific to the area, for example, like withstanding earthquakes. California's state housing law sets minimum construction requirements and occupancy levels for dwellings. Under this law, no construction or building alterations are allowed until the plans for construction are reviewed and approved by the local building inspector and a permit is issued. Building permits are issued locally as a signal to a builder or contractor that building codes must be followed. During or after completion, building inspectors review work to ensure building code compliance. Most municipalities allow existing construction to be sold and occupied without meeting current building codes. However, any unpermitted work should be disclosed to buyers. State and local agencies work together to ensure that building codes are met. This includes enforcement of sanitation requirements by a local health officer. Construction standards are maintained in part by requiring that most work be supervised by general contractors licensed in the state. The licensing authority is the Contractors State License Board. Contractors wishing to obtain licensure in California must meet education, experience, and examination qualifications and post a bond with the state. If materials and labor will cost more than $500 for a construction or remodeling project, a licensed contractor must be used. Certain exemptions exist, including an owner's own work on a building that isn't intended for sale within 1 year of completion. Environmental hazards and regulations. Licensees should be aware of a variety of hazardous substances that might be present in or on properties they show, list, or sell. Licensees don't have to know how to investigate environmental issues, but should know how, where, and when to seek expert assistance. Licensees should recommend that clients engage the appropriate experts to perform interior home inspections as well as soil, air, and water tests, if indicated. Licensees should always document recommendations made to clients, particularly if a client declines environmental testing. Types of hazards.
These are silent killers. Asbestos.
Asbestos friable is a fibrous material that's dangerous when it begins to deteriorate and becomes easily crumbled or reduced to dust. It was used in many materials before the 1970s because of its fire retardant qualities. Airborne asbestos is dangerous because inhaled particles can cause lung damage and cancer.
We have asbestos in the ceilings.
The EPA and California state law regulates asbestos use, handling, and disposal. Only licensed professionals should handle asbestos. Homeowners can hire certified asbestos consultants to assess asbestos danger and for abatement procedures. No federal laws require abatement of asbestos in residential properties. Lead. Lead can be found in paint, plumbing, dust, soil, and drinking water. Lead causes many health issues, particularly among infants, children, and pregnant women. In children, lead-related issues can include behavioral problems, learning disabilities, seizures, and even death. The Residential Lead-Based Paint Hazard Reduction Act requires specific disclosures to buyers and renters of residential property built prior to 1978. These include disclosure of known lead-based paint hazards, providing an EPA-approved information pamphlet, and 10 days to conduct a lead assessment. The EPA designates homes built prior to 1978 as target dwellings because they're more likely to have lead-based paint. The federal government doesn't require lead abatement in homes, but some states do require it. The Federal Lead Renovation, Repair, and Painting (RRP) rule requires contractors who perform tasks that may disturb lead-based paint to be certified and to follow lead-safe work practices.
And we have radon.
Radon. Radon is a naturally occurring gas that can be found in soil and well water. Radon enters a home through a building's cracks and crevices, and experts believe it can cause lung cancer. Some areas of the country are more likely to have high levels of radon, but licensees should suggest sellers test a home for radon and take mitigation action if needed before putting it on the market. Buyers should ask for a test prior to completing the transaction. Homeowners can purchase radon self-test kits and send them to a lab for analysis. The highest levels of gas will be found in the lowest levels of the home, such as a basement. Results are measured in picocuries. If the home tests at or above a level of 4 picocuries per liter, experts recommend mitigation, which can include sealing cracks and other foundation or basement openings and installing a vent system. Radon mitigation isn't required by federal or California law. Mold. Mold growth is promoted by excessive moisture and lack of air circulation. Excessive levels of mold can cause allergic reactions or act as a respiratory irritant in individuals who are sensitive to it or are immune compromised. In some cases, molds may release potentially toxic substances. In residential environments, no federal regulations exist regarding mold testing or abatement. Some states have laws that govern mold remediation. The EPA recommends that an expert remediate affected areas larger than 10 square feet.
We should really have the office's air quality tested.
Carbon monoxide. Carbon monoxide is an odorless, colorless, and tasteless toxic gas that's formed from fuel combustion. Gas appliances must be properly vented to the outside to prevent buildup of carbon monoxide indoors. Improperly functioning gas and oil furnaces, gas refrigerators, clothes dryers, ranges, water heaters, and space heaters may be a source of carbon monoxide, as are automobile exhaust, fireplaces, charcoal grills, and wood-burning stoves. Initial symptoms of carbon monoxide poisoning are dizziness and nausea. California recommends carbon monoxide alarms in all single-family dwelling units. Volatile organic compounds, VOCs. VOCs can make indoor air quality toxic at high levels and may be found in some air fresheners, cleansers, paint, and building materials. Leaking underground storage tanks can contribute to groundwater contamination. A variety of federal and state laws protect groundwater. Underground storage tanks are most likely to be found in older construction and former industrial sites. The Division of Water Quality oversees California's underground storage tank program, including leak prevention, cleanup, enforcement, and tank tester licensing. If you suspect the presence of a UST, research when and how it was decommissioned. Waste disposal sites, or landfills. Landfills are typically huge, excavated areas where waste is buried underground. Federal, state, and local governments regulate waste site placement, construction, and content. Rural properties, or properties that were once in rural areas but have been swallowed up by a metro area, may also contain sites where property owners once dumped trash. Inactive waste sites are often capped, covered with soil, and ventilation pipes are placed from the base of the waste site through the cap to expel accumulated natural gases created by waste decomposition. Test wells are installed and monitored to test for groundwater contamination. Golf courses, parks, and housing and office complexes are often constructed on these capped disposal sites. Hazardous wastes are disposed of at special purpose landfills. Special purpose landfills are usually located in remote areas, away from human contact, and are subject to strict regulation to prevent the escape of toxic substances. Properties that have been contaminated by commercial or industrial use may be referred to as brownfields. The Brownfields law, enacted in 2002, provides direct funds, mostly in the form of grants, to assess and clean up brownfields. Contaminants at these sites include petroleum, industrial waste, and even waste and byproducts from methamphetamine labs. A Superfund site is one that the EPA has determined presents a potential threat to human health or the environment as a result of uncontrolled hazardous waste, and which requires remediation. Licensees must disclose the existence of a nearby Superfund site to prospective buyers. The Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, was established to clean up closed, abandoned, or uncontrolled hazardous waste sites and spills. The EPA identifies Superfund sites and is authorized to oversee the process of remediation. The Superfund's Amendments and Reauthorization Act, SARA, added an innocent landowner defense to CERCLA. Landowners who performed their due diligence when purchasing a property may be held innocent of cleanup liability if the property is found to be contaminated. Either buyers or sellers may be liable for cleaning up contaminated property. Strict liability. The property owner is responsible for cleanup regardless of who's at fault. Joint and several liability. Each of the responsible parties is personally responsible for damages. Retroactive liability. Both the current owner and prior owners are liable. If liable parties aren't doing cleanup, the EPA can hire its own contractors, do the cleanup work, and then bill the parties. California requires disclosure related to 6 types of natural hazards. Special flood hazards areas, areas of potential flooding due to dam failure, high fire hazard areas, forest fire hazard areas, earthquake fault zones, and seismic hazard zones. Licensees should be aware of environmental issues pertinent to the area where they work. Such issues may include coastal areas may experience faster decay of building materials and erosion of soil. Building may be restricted by local policies related to the California Coastal Act. Earthquake and seismic hazards are an issue in some areas, and fire hazards may require additional work from the homeowner to maintain a defensible area. Noise may be an issue from airports or highways. Private controls. Private land use controls place restrictions on the appearance or use of land by individuals or private entities as opposed to those placed by a government body. Private land use controls include easements, liens, deed restrictions, and subdivision regulations or HOA rules, including CC&Rs. Deed restrictions are private restrictions that may be placed on a deed at any time by the owner. The restrictions apply to the specific property. They run with the land, meaning they remain associated with the title and generally can't be removed by new owners. Some deed restrictions may have a time limit and will no longer exist when that limit is reached, but most stay with the property forever once created. Covenants, conditions, and restrictions, CC&Rs, are a form of private land control used in a subdivision or community. CC&Rs are typically placed by a developer on parcels in a subdivision and apply to all properties in the development or community. Covenants are agreements or promises between parties. For example, homeowners in a covenanted community may agree to abide by the community rules as part of membership in the homeowner association. Conditions are a requirement of a conveyance and create a fee simple defeasible estate where violation of the condition may result in a right of re-entry or possibility of reverter. The deed must contain phrases such as "for so long as," on condition, or "provided that," to create a condition. State law may limit the use of conditions. A restriction limits how the land can be used. It may be a deed restriction if it appears as a clause in the master deed that applies to all properties in the subdivision. Each property's deed usually makes reference to the CC&Rs found in a master deed or declaration of covenants. The declaration is generally recorded in the land records in the municipality in which the property is located. Even though CC&Rs are not necessarily in the deed to each individual property in the development, they apply to all in the development. Typically, the CC&Rs include a requirement to establish a homeowners association. Once the HOA is formed, the declaration of covenants then becomes an agreement between the property owners and the HOA, including the obligation to pay the HOA fees. CC&Rs subject property owners to certain rights, responsibilities, and obligations. They regulate how the property may be used and its appearance. The HOA, or any member of the HOA, may pursue enforcement in a court of law if a resident isn't complying with the covenants. Doctrine of Laches. Regulations that aren't enforced may become unenforceable under the doctrine of Laches. The Common Interest Development Open Meeting Act says that an HOA meeting agenda must be posted at least 4 days prior to the meeting. An HOA board is prohibited from taking action on any item of business outside of a board meeting. California's Brown Act, which gives the public the right to attend meetings of local legislative bodies, also applies to HOAs. This act also prohibits a board from discussing business without a majority of members present, including any email communication. Water rights. Water rights are especially important for agricultural use or in areas where a well is needed or water is scarce. 3 categories of water rights include riparian rights, littoral rights, and the doctrine of prior appropriation. Riparian rights address water that moves through a property, such as via a river or stream. Riparian rights are classified into one of 2 categories based on the type of water: navigable or non-navigable. Littoral rights address static water, such as water in a pond, lake, or ocean. Owners with littoral rights have the right to use and enjoy the static water, but not to divert or contain it. Prior appropriation. Prior appropriation says that the first party to physically take water from a source and put it to a beneficial household, agricultural, or industrial use will continue to have a claim to that water. These are also called appropriative water rights. Also, really quick, to remember the water rights: riparian, river.
Just around the river bend, just around the river bend.
Rivers are rippin' and roarin', they're riparian. River, riparian. Littoral rights, literally a pond, literally a lake, literally still a lake. Prior appropriation.
I was there first.
Finders keepers.
I already used it. Okay, that's all I got. Riparian and littoral rights run with the property and aren't sold separately. Where prior appropriation is used, water rights may be transferred away from the property. California law uses a combination of riparian rights and prior appropriation. Landowners with riparian rights don't need permission or license to exercise their right. They may use a share of the water that flows past their property, but may not divert or store it. Landowners seeking rights to water that's subject to prior appropriation must follow a permitting process. Landowners have the right to use percolating groundwater as long as it's put to reasonable use. In most parts of the state, no permit is required. Special categories of land. California defines 6 types of land considered natural hazard zones. If the property is located in one of these zones, the transaction requires disclosure of that fact. The 6 natural hazard zones are: Special Flood Hazard Area, as identified by the Federal Emergency Management Agency, FEMA. Area of potential flooding due to dam failure. High Fire Hazard Severity Zone, as identified by local agencies. Forest Fire Hazard Area, as identified by the State Board of Forestry and Fire Protection, where fire protection services may not exist. Earthquake Fault Zones, as identified by state geologist maps. Seismic hazard zones, as identified by state geologist maps, which include the potential for landslide or liquefaction from earthquakes. Alquist-Priolo Earthquake Fault Zoning Act. This act prohibits building on fault lines, requires disclosures to purchasers of dwellings in earthquake fault areas, and sets requirements for permitting projects when retrofitting existing dwellings in these areas. This act is applicable to any project intended for human dwelling within an earthquake fault zone. California regulations limiting development in environmentally sensitive areas. California Environmental Quality Act, CEQA, requires an environmental review review before approving development projects that may impact the environment. This applies to all projects requiring governmental discretionary review. California Coastal Act establishes environmental protections for development near coastal areas and wetlands and protects public access to beaches and waterways. Rangeland, Grazing Land, and Grassland Protection Act protects California's rangeland, grazing land, and grassland through the use of conservation easements and prevention of the conversion of rangeland, grazing land, and grassland to non-agricultural uses. That is land use. You made it to the end. Subscribe and come back to study again tomorrow. Your next topic is right here. Click it and keep the momentum going.